Good morning to all of you. No response. Good morning to all of you. So nice to know. So nice to hear. Right. So, at the outset, as usual, let me thank the organizers for inviting me here, specifically Dr. Sunil Masare, who has been the backbone of this particular conference and the president of this particular IMA, Dr. Prahlad Kotkar and Dr. Sunil Chandolkar. So this team, let me thank this team for inviting me here. थोडंसं मराठीतही बोलतो. आपल्या सर्वांना हे माहिती आहे पहा की कायदा गाढव असतो. हे माहिती आहे का? आपण ऐकलंय कधी? बऱ्याच वेळेला ऐकलेलं असतं आपण. पण प्रत्यक्षामध्ये अनुभव येतो का आपल्याला तसा? तर प्रत्यक्षामध्ये तसा अनुभव कदाचित ज्याच्यावरती वेळ येते त्याला तो अनुभव येत नाही, किंवा कदाचित पुढच्या स्टेजेसमध्ये जेव्हा तो सफर होतो तेव्हा त्याला हे समजतं की कायदा गाढव आहे असं जरी आपण म्हटलं तरी देखील काही गोष्टी आपल्याला ऐकायलाच लागतात आणि त्यानुसार पुढे जावं लागतं. So coming to our own topic, see, I am thankful to the organizers for rescheduling my talk today instead of tomorrow, because I was supposed to be there tomorrow, but this has been rescheduled. I am thankful to them. As such, if we decide to have interactive sessions, it's actually a pleasure to know that this conference is for 2 days and multiple topics and multiple faculty who are experts in their own fields, they have been invited, and it's a feast to all of you. Now let me accept this, that amongst all medico-legal conferences where I was a speaker or which I have attended, this conference is having maximum attendance. I have not seen till now, even at a national level conference, my experience is that there are hardly 4, 5, 6, even so doctors who are interested in listening to the speakers. So I thank all of you for gathering here in a large numbers. Basically, being general and orthopedic surgeon, practiced for 20 years, then got the legal qualification, LLB, LLM, then PhD in law, of course, specifically my PhD, which I obtained in 2013, changing trends in the law governing medical negligence under Consumer Protection Act. So, I studied this for almost 6 years, analyzed number of cases of the National Consumer Commission and this Honorable Supreme Court of India, and came to the conclusion that application of the Consumer Protection Act to the medical profession in 1995 actually has not done good to the medical profession. This was the conclusion, and of course I have given many suggestions at the end of this particular PhD thesis. Fortunately, I got the opportunity to be on this side in the State Consumer Commission. It's, we can say in the layman's language, it's a high court of a consumer system, consumer court system. So I was a non-judicial member for 5 years. At the end of the tenure, I got the opportunity to become the chief judge, we can say, the president, in-charge president of the State Consumer Commission. And the experience which I gathered as a doctor, there are so many aspects which I think the medical professionals should actually take a cognizance of the trends which are changing in this medical legal field. Now I also must say that I have been accompanied by one of our esteemed former district judge, Mr. K.R. Devsarkar sir. So he is there accompanying with me. So he was the District Consumer Commission NANDED president for almost 5 years. So he has decided a number of cases even against doctors, I am sure. So in his presence, I am actually now deliberating on certain aspects of the Consumer Protection Act. Now, as a doctor, whenever I used to think that when the judges who are sitting on this side do not know ABC of medicine, when the advocates who are representing both the sides, when they also are not knowing ABC of medicine, but whatever, as a doctor or whatever the client, we can say, educates the advocate, with the help of that, he represents any of the side, that the patient side or the doctor's side. The patients don't know anything about medicine as well as law. Still, the judgments and the orders, when come from the court decides cases either against or in favor of doctors. So how this happens? So I always used to wonder. But then with this experience of working as a member or the judge in the State Consumer Commission, I came to know that there are certain established principles with the help of which, of course, these principles come from the enacted act. Now, you must have learned that the Consumer Protection Act 1986 has now been replaced by the Consumer Protection Act 2019. So, new act has come. New act, completely new act has come, and it has replaced the previous act. Sometime when this act was implemented, amongst all our medical professionals, we had a very much excitement that now the medical profession is not there in the new act, under the purview of new act. So this was circulated in the WhatsApps and all, so we were very happy. But then, this has not been proved to be true. Finally, I think about 6 months ago, Honorable Supreme Court has also applied a seal of approval that even the new act is applicable to the medical professionals. I'm not going to go to the technical details, but some technical details which are useful to the doctors I'm going to discuss definitely. So I'm going to actually talk on, of course, I think the time is very short. On 4 topics I'm going to speak, so let me go on very rapidly and fastly. Regarding the Consumer Protection Act, a brief review I'm going to take. Yes. So the new act applied on 20th of July 2020. From that, the further matters or the complaints, they were placed under this particular act. And the main question was that whether this act was also taking care or dealing with the matters of medical negligence. Of course, there are certain modifications and changes they were suggested and they are implemented as well under the Consumer Protection Act. You all must have seen this particular figure. What is the meaning of medical negligence? And these medical negligence matters and the cases, they are dealt with under the Consumer Protection Act. And those who have faced the music from the consumer protection or consumer courts, I'm sure they have the experience that how much stress they have. Recently, it has been proved that after the application of Consumer Protection Act to the medical profession, there has been a great increase, more than 450% increase in filing cases, consumer cases against the doctors. For last 25 years, from 1995, as I was discussing, some settled principles, and see, landmark judgments are the judgments delivered by Honorable Supreme Court India. In all these judgments, certain principles, the Honorable Supreme Court comes out and these principles are applicable to all the courts or all the cases similarly being filed under all courts as such. So these are the landmark judgments. 16th of January 2008 was the date on which the Samira Kohli judgment was actually pronounced. Samira Kohli, I think you all are aware, Samira Kohli judgment. So by this judgment, Honorable Supreme Court has given certain principles of how informed consent should be. And this was hotly discussed in all conferences, and then we all are now aware that for every intervention, medical intervention, informed consent is necessary. So only for informed consent there can be 2 days conference. So that's the importance of the informed consent as such. Going ahead, how a doctor is judged to be liable for his act. These are certain basic principles. There is a Bolam principle, Bolitho principle. Of course, these principles have very exciting history as such. And if you go and read these judgments and the principles, you will come to know that it's very interesting to read and learn about these principles. Then this is about the consent as such. Bolam principle, way back in 1957, Bolam was a patient. The judge came in favor of the medical professionals, said that whenever doctor follows the treatment or the principles of treatment are same as the doctors of his own community or own specialty, then he is not negligent. It's a simple definition of liability as such. And then this Bolam principle has helped the medical professionals all over the world. But now trend is Bolam principles is being replaced by Bolitho principle. What Bolitho principle said? 1997, again a UK case. I'm going very fast actually because we have very less time. The Justice Brownie Wilkinson, he said in this case, Bolitho case, that even if the expert opinion is there in favor of any side. See, in any court case, the expert opinions are laid down before the bench. One favoring the one side, the other favoring the other side. So here, Justice Brownie Wilkinson said that, okay, the expert opinions, though they are placed before the bench, the expert opinion which can be accepted on the basis of logical analysis. That means we can say in layman's language the simple thinking whether it can be accepted. In short, whatever judge thinks right should be the logically accepted consent. So this went, the ball of this particular liability or acceptance of liability completely shifted to the other side. And then all over the world this principle was used, and then what happened? The cases were not in favor of doctors. So this happened. Even in India, gradually this is coming, and you please, Google is our now friend, so you please access and then get the information about what is the Bolitho principle. Next change is, now the doctor is not God, though sporadically we get an experience that the patients definitely, they owe everything to us. That means they say that you are God for me. But now doctors are service providers. Patient equated to consumer. Medical negligence, in addition to the negligence by doctor, it is the deficiency of service is added. Expert opinion, as I was discussing, it is accepted only on the basis of the logical analysis. And approach to the compensation. Compensation, this is again being very hotly discussed, and we always hear that the exorbitant compensation must not be awarded, and there should be capping of compensation. But in one of the judgments, I am not going to quote any judgment or any citation as such, in one of the judgments it has been mentioned that if the complainant, that means in our case patient, prays for punitive compensation, means punishment to a wrongdoer doctor, if it is prayed, higher compensation can be awarded. higher compensation can be awarded. So this is what is the change over the period of time. And this is the biggest thing which is happening. It is a violence against doctors. Everybody is worried about it. A simple injection given, Boveron given, reaction comes. Sometime patient died there itself. Then the doctor has to face the music. So can anything be done to prevent the violence? This is the biggest question now we have. Now we come to the Consumer Protection Act 2019. I'm going to take it very rapidly. I'm going to just show you some overview as such. There are, in the new act, as compared to the previous act, which had 31 sections, now there are 107 sections. So 3 times sections have been added. New additions are there. There are 8 chapters and introduction of 3 or 4 new chapters. That is, the Central Consumer Protection Authority has been newly added. Concept of mediation has been newly introduced, and the product liability has been newly introduced. So these 3 to 4 things which have been newly introduced. I'm going to take you just very rapidly. The Consumer Protection Councils, section 3 to 9, only advisory capacity. Councils are at the 3 level. Central Consumer Protection Authority, sections 10 to 27. It's a new mechanism having autonomous authority and power to even send a notice as well as suo motu take action against the wrongdoers. So this is what is the CCPA. Consumer Disputes Redressal Commission, sections 28 to 73. Now these sections take care of the 3-tier machinery, district, state and the National Commission. Of course, we are aware about the this particular system because the cases can be filed before these commissions. Mediation, new concept. Only thing is that cases of medical negligence, now where there is a death or some grievous injury has been taken place, these cannot be referred to the mediation. Mediation is a stage before hearing of any case, but they cannot be referred. Product liability, of course, I am skipping this. For us, the products supplied to us while treating the patients, whether they can come under this particular product liability, the answer is yes. Offenses and penalties, various aspects have been discussed. If suppose a person against whom the order has been passed, he doesn't comply, then there are certain provisions how that should be dealt with. So these are the sections, and this chapter deals with the offenses and penalties. E-commerce rules, of course we are aware, Amazon, Flipkart, and if suppose we get faulty product, then the person can approach the consumer court. Now, of course this is somewhat old discussion, whether the Consumer Protection Act is applicable to the medical profession. There have been several discussions. I am not going to take it into the detail, but finally this act is applicable to the medical profession as such. So this is simply in the new definition of services which are covered under under the Consumer Protection Act. Though there is no mention of the medical services, there is definitely one word, that is, it includes but not limited to this list. So this is the, we can say these are the words. With this provision, the medical service has been included under the Consumer Protection Act. And this is the biggest thing which for a consumer court, there is unfair contract and unfair trade practice elaborately defined under the new act under section 2, subsection 46 and subsection 47. Now, you all are aware about the Indian Medical Association versus BP Shanta. I am not going to go again into the details because this is the act, this is the rather case law by which medical profession was brought under the Consumer Protection Act. Yes, so this question have been answered. Now I am going to stop here and going to start with the another, how a medical professional should actually deal with